So Ellie just celebrated pre-show by flopping down behind my chair on her back, like, pet my belly and do it now. So that's how we spent the 60-second countdown. So hi, everybody. Welcome to Sidebar.
Hello.
Hello.
As Michael finishes his dinner.
Yes, well,
man.
You know what?
It takes.
It's like 5 minutes before showtime. Gotta wolf that food down. That's what I'm doing.
Big bites.
My apologies.
No, you're fine. I'm just grabbing a cat who decided to jump on top of the printer, which we generally discourage around here because that's probably enough with these modern day printers for it to get its self-destruct code sent to it, because you know that every printer does now.
Yes.
So
ain't that the truth?
Don't want that. So welcome everybody, and Wahoo, welcome back. It's good to have you back.
Oh, good to see you, man.
So we were going to talk about pro se defendants tonight, which is something that we've touched on before, but it's always a good conversation. We'll expand it. Specifically, we had this guy in Judge Oakley's court a couple of days ago, who I'm pretty sure we had seen before that hearing, because I remembered them talking about stuff previously. But he was just determined to go this alone, and it turned out to be a big old mess with a threat of contempt at one point, and then him ending up making a deal. So I don't know why so many people insist on going pro se. He kind of had quasi-Sobsit kind of logic too in spots. Yeah. So maybe that was part of it.
Yep.
But I think that's our launching point for this discussion, and then we can kind of go from there.
Yeah, it was kind of quasi because he was trying to reference a civil statute and Judge Oakley kept saying, we're in criminal court, you can't cite that. It was something about let's see, it was for
process service, I think part of his argument was going to be that he wasn't served properly.
Yeah, service of process, correct.
Yeah.
It didn't apply to criminal matters. Yeah, and he was just referencing the wrong thing. So it could be like quasi soft sit, but I don't think he knew what he was doing or didn't know any better, is what it kind of came off as.
No, I mean, there's definitely a difference between going and looking up law and then actually being able to understand and interpret it.
Yes.
And I would never claim to be an expert at that, despite all of the hundreds of hours of court at this point that I have watched. I still, every now and then, as we're watching videos, I go and I pull up some code, and it's not easy to read, and it's not easy to understand. Nope. But Austin, you can probably speak more to that because this is, along lines of what you do.
Yes.
Does it ever get easier?
No. I catch myself having to go back and look up stuff all the time. And I still have a bunch of my paralegal books and everything that I'm always researching stuff and re-looking it back up.
So you're like, you're a never-ending learner then. Of your field. I see. Cool.
And then they go in, they add or delete code every 2 years. And so you're relearning that as well.
So I got to ask, it's a bit off topic, but I'd be curious of your opinion. Do you think that the codes are written that way so that they are exacting and accurate, or are they written that way so that it's easier to gatekeep?
Yes.
Thank you for your honest answer.
It's tricky, and part of me says yes, it is to keep the industry alive, but part of me is like, I really don't know. It does take a lot of research if you're going to do it yourself.
Well, a lot of this stuff too, you have to remember, I mean, legislators, which are prized in part of lawyers,
Yep.
love to rewrite code, maybe to make themselves feel useful, like they're fulfilling a purpose outside of just signing other, crazy things that their pet projects into law. They also want to make sure that they update the code and keep their friends busy. I don't know. There's a number of reasons why, but
I can't.
this guy was kind of a little bit soft-sit. But I think some of it is there are just some people that think that, hey, if I crack open a law book, or if I watch enough Law and Order,
Yeah.
or I've seen a lot of episodes of cop shows on TV. I've watched a lot of NYPD Blue or what. I know enough about the law. I can get by. I'll be able to figure it out, because I'm smart. I can outwit all of these people. So I think there is a little bit of that too. Sometimes it's soft sit, yeah, for sure. And then sometimes it's just people are just genuinely ignorant. And I guess there's also that small aspect too, that some people are like, well, I can't really afford an attorney, but
I think this
too.
is the case of this guy because I don't think he could afford it because one, he went into court wanting to represent himself. He wanted to go to trial. But then when he realized that he can't do it himself, he automatically folded into a plea deal. But
Yep.
I think, where was I going? Or I lost my train of thought. Yeah. But anyway, he I don't know. I feel like there's a difference between learning what to say in court or versus actually applying it to court. Because actually learning the law, correct me if I'm wrong, Austin, because I have no experience in this, but learning the law and what it says versus actually applying it to your case are totally
Knowing
different.
what it says is one thing.
A totally different
when
thing.
to use that statute is another.
Yes, and I think he did.
Yeah.
I think you only learn the second part by practice, and since he didn't have that practice under his belt, and he only knew like what the law said and not how it applies to him, of course, it couldn't be used because it didn't apply to him. So I think that's a big thing there.
They see one little part of a code, but then you have all the asterisks and the subsections, and people often don't look at that. They'll see the main code statute and think that's it, but down at the bottom it could be something where it says if this happens it doesn't apply, or XYZ.
Like all the subsections underneath.
Yeah.
Well, and then they'll see that, or what happens is they'll quote a part of the law that may actually be completely correct and totally on their side, but that law was changed 2 years ago or 4 years ago. They're looking up old information, and just like we talk about in the weather world, when you're working with old information, you're working with bad information, and that's
correct.
That's sometimes what happens too. Is there are some people that might even be smart enough to make their case, and as Austin sort of said, they know the law, but they don't know how to apply it, particularly as it's germane to their own case.
Yes.
Yeah.
So Wahoo just said, I'd rather file my own taxes than go pro se. And that kind of goes into something I was just thinking. I think through a lot of different things that I've done in my life or handled. Taxes is one of them. I do my own taxes despite the businesses that we run because I know how to do it. I've learned over the years, and I feel like I know my business better than any accountant's going to at this point.
Yeah.
I'm good at working on my car because I've had some experience with it. And if it's something that I don't know how to do, like the other day, I had to replace the thermostat on it when I've done thermostats before, but not on this car. And it was totally different, but I was able to look it up and, okay, that's where it is. I can do that. No big deal. There's certain things that I feel like, even though it's not necessarily what you do all the time, you can figure it out, right?
Yeah.
The law is one of those things that I have a hard time believing that applies to. It's too specialized. It's like, and your freedom is potentially at risk.
Right.
That's the biggest
Right.
thing. Whether or not you want to deal with it. I mean, it's like, for lack of a better example that's coming straight to mind, it'd be like getting a cancer or something. Whether or not you want to deal with it, it's in front of you, and you're going to need an expert to get you through it.
Yeah.
Right. Exactly.
And that is kind of, I relate it to doing my taxes this year. I usually do my own taxes. However, there was a unique circumstance that I didn't know how to do. I didn't feel comfortable doing it. So what did I do? I hired a professional to take care of it for me. And I think, and then maybe next year when I'm not in that situation, I can do it myself. But I feel like this is, like Dan said, this is such a specialized field of expertise that certain documents, certain things are needed. And I hate that the court spent all this time just to settle into a plea. I wonder how much time it took for them working on this between the prosecutor and the defendant. So I can only imagine. I'm not sure how long it typically takes, but it's probably triple the amount of time, I would think.
Well, if this is the guy that I think it is, and I'm about 85-90% sure that it is, then we saw him a couple of months ago.
Yep.
And Judge Oakley was begging him at the time to take an attorney. And you talked about maybe he couldn't afford one. I'm pretty sure he was offered a public defender.
Yes.
I believe he was as well.
Oh, yeah.
So, but it was like pride taking him over, or again, some kind of sob sit adjacent thinking. I'm not exactly sure, but he had offers to not go down this route.
Yep.
He had time to prepare when he chose to, and he was still throwing up arguments. Like, he was trying to bring in this stuff from Monroe County, which had nothing to do with it. And judge kept telling him, I don't have jurisdiction over that. There's nothing I can do about that. And it doesn't apply to this case. So I'm not going to let you bring it into the jury. But he just kept going on and on and on about it. Mm-hmm. So just totally out of his league.
Yes.
But we see this a lot. And it's so confusing to me, again, especially when you're offered a public defender. Is it going to, is that the Cadillac of lawyers? No. Is it still going to be better than what you're going to be able to do? Yeah.
Yes.
Absolutely. Yeah.
At least they have experience.
Yep. And in some jurisdictions,
that's a major thing.
And in some of the jurisdictions, the PDs, public defenders, have almost more experience than anybody because they're so used. I'm not sure if that's their jurisdiction or if it's elsewhere, rather.
And I'm not remembering anymore which judge said this. Part of me thinks it was Middleton. Part of me thinks it was Fleischer. But one of them actually argued that if they were going to go to trial on something, they would rather have a public defender because the public defender has more experience going to trial than most actual private attorneys who will plead stuff out.
Yeah.
So if he was so insistent on getting this thing in front of a jury, he probably would have been better to just take that public defender offer. Not probably, he would have.
Yep.
Yeah.
Absolutely. Yeah.
Agreed.
Because after all that wasted time and effort and everything else and calling in that jury who would have just been sent home, the result is the same.
Yeah.
It's
Well-
just somebody that's way over their head. I just don't. I feel like he could. I think he really thought he could handle it, and that it would be a piece of cake. He'll just. They do it all the time in court. Like you said, Dan, Law and Order, or something like that, maybe. Or it wasn't Mike that said that, but somebody mentioned. I think Mike said Law and Order, but you see court on TV, and it's so seamless, and it seems so easy. And but if you don't know what you're referencing, how are you going to speak about? How are you going to defend yourself? And I think that's where it falls apart for sure.
Well,
It's interesting what you just said. You talked about it like seeming like looking seamless and all of that when you're watching like Law and Order.
Yeah.
There's a reason for that. There's a script and good editing.
Yeah.
But if you look at real court like we watch here, it is anything but seamless. Some of the best lawyers are up there going every other word.
Yep.
Yes.
As they're trying to form their thoughts on the fly, and they do this for a living, you know?
Yeah.
But
crazy.
but
I would
it's
be
weird, isn't
nervous
it?
in
Like-
that situation. I'm an over preparer in a lot of cases, and I mean not court cases, but in a lot of examples, I over prepare for things. And this would not be something I would feel comfortable standing in front of a judge and a jury and do, let alone somebody else that doesn't have any court experience. I just, no. I understand that they have the right to self-represent themselves, but as we spoke about before, should you? No. This is something that you need to leave to a professional. This is not something you do every year, let alone every day.
Well, some of these people do it every year. If
Well,
not every
yeah,
day.
maybe some people do it every year, but not this guy.
Especially the misdemeanor courts.
Not this guy. So yeah, I think just leave it to the professional. I think that is the major advice here.
Well, and it falls back into the old argument. Yeah, just because you can do something doesn't mean you should. And how many times have we seen this? I mean, even skilled attorneys can make bad arguments sometimes, or they can. We've certainly seen judges come down on regular, licensed, practicing veteran attorneys.
Yeah.
Oh yeah.
Let alone somebody that's just a pro se person. Now, look, every once in a while, we've seen a couple of pro se people do okay in like a traffic court setting, because while traffic code certainly can be rather technical, you can, and I think this is one area where, an attorney, you don't necessarily have to have one.
Right.
Look, sometimes the codes, traffic codes, there's a little bit more of a, hey, it's this or it's this, and there's not a lot of wiggle room in between.
Right.
Or if there is subject to interpretation, the judge might be more willing to listen to you and hear you out on your side. I have heard a few defendants successfully argue their way out of a ticket in a traffic court setting. So, maybe something like that. Obviously, in small claims court where there are no lawyers, there's that. There's people can make their arguments there, and that's a little bit different too. Yeah. But even on the civil side, once you get out of there and you're into, more of a higher court setting, you should still have an attorney. I mean, civil law is just as complex as criminal law in different ways. I mean, because then you start talking about not only, sometimes you can get into the nuts and bolts of the tax code. And, we talk about doing taxes, which can be pretty complicated in itself. But then if you're in litigation, you combine the tax code with just, state statutes or federal statutes. I mean,
you're looking at 4 or 5 different
Yeah.
sections of statutes and laws and codes. And
right.
confusing really quick.
There's another point I want to bring up because this is something I thought about before coming on, but it's the pro se's expectations when going to court too.
Yep.
I feel like when a pro se goes to court, they feel like they're going to have all this help. They're going to get all this knowledge from different people, and it's just not like that. Even judges are very limited on how they can help or how much they can say. They can't advise him to do things.
Yep.
And the prosecutor doesn't even want to I don't think they can advise to do things either. They have to find things out for themselves, and I think that's a thing that a lot of, it's not like school, when you go there, you get kind of led into a certain direction and told what to do. In this situation, you're not done. That does not exist, and I feel like a lot of pro se's are in over their head because of it too.
That, or they go in and they feel like if they say everything from A to Z that happened, that they're going to win, but in fact, they could say something that could actually hurt themselves worse, too.
Yeah, that too.
Because they just don't know that they shouldn't say that.
Right. And that's just it, too, right? I mean, you still have to follow the rules of evidence.
Yep.
There's still these procedures just for having something admitted, like an exhibit,
the paperwork,
admitted into the record, and how you go about doing that, what questions you're allowed to ask. And judges sometimes will give a pro se person a little bit more latitude than they would somebody else, and it depends on the setting too. Obviously, in a family court setting, there's probably a little bit more latitude given as well, because it's a slightly different scenario. Now you're not talking about criminal court. It's more civil. Well, many would argue it's quite uncivil in family court, but I mean, but it's kind of this. It's a different setting altogether. So you are allowed a little bit more leeway, but in a criminal proceeding, generally speaking, you still have to follow the same rules that any practicing attorney would follow.
Correct.
And I just think about some of the crazy pro se cases that we've seen either here on TCF or just in the media in general, and some of them high profile. You had the guy that ran over all those people in Wisconsin.
I was thinking about that one actually.
Kenosha,
Yep. And then of course, we all know Lori Vallow represented herself in one of her cases. Well, the one here in Arizona. She was not accused of. She did some terrible things. She killed her ex-husband and her children, and her and her new husband, and so just terrible. And there's many other high-profile examples of this stuff. So, this is something we see a lot of. This is not something that is an occasional thing that happens. There's a lot of fine examples of it, and again, outside of the traffic court setting I mentioned earlier, very, very, very rarely, although it may happen now and then, very rarely do you see a pro se be very successful.
Correct.
Yeah, and even if a pro se or somebody wants to go pro se, I think there should have standby counsel at the minimum. I think they should have somebody on standby just in case they can't go through with it. They've realized they're in over their head, and they have somebody on the side that will help guide them through the court process because they've done it before. That would be my advice to a pro sayer, but other than that, I don't think you should do it, and I don't think it improves anything. I think it just makes things really complicated for everybody. I know there's irrelevant filings that happens too by a proseyer. They don't know what to file. So the court is backed up with all this paperwork that was filed by the proseyer, and it even slows it down even more. It mucks everything up. And I think it's just better for them to get a standby attorney and it kind of handle that paperwork for them, and they'll handle the trial or something like that. I don't know, but that's the only way I can see that it would work efficiently anyway.
Yep.
So while you guys were talking, I did a little homework. Would you like to have your mind blown?
Uh-oh.
Uh-oh.
All
Yeah.
right.
Oh boy, let's do it.
Settle in.
Erica Hashimoto in 2007 did a scholarly study for the University of Georgia Law School. She looked at around 250 cases. Overall conviction rates. Just under 50% of pro se defendants were convicted of any charge versus 75% for represented defendants. Felony convictions. Only 26% of pro se defendants ended up with felony convictions versus 63% of those who are represented. Plea outcomes. Pro se defendants who pleaded guilty were far more likely to plead to misdemeanors than felonies. 47% misdemeanor versus 53% felonies, compared to representative defendants who were 16% misdemeanor and 84% felony.
Wow.
So maybe you should represent yourself then. Never mind what we said.
Wow. So that's fun.
Furthermore, if you're worried about mental illness, 80+% showed no signs of any outward mental illness when they chose to represent themselves. Just under 20% did. So, according to Erica Hashimoto in her scholarly paper, you may be better off, in some cases at least, to represent yourself.
And this is from 2007.
2007.
Yeah.
And it did mention, and it did say more common for misdemeanors than felonies, though.
No, it was more common that they would get a misdemeanor plea than a felony plea.
Oh, I see. Okay, got it.
Yeah. If you're represented, it was much more common that if you were representing yourself, you had a 47% shot of pleading to a misdemeanor. So they would plea you down. As opposed to if you were represented by an attorney, you only had a 16% shot of pleading down to a misdemeanor. Wahoo, thank you for gifting the membership. I appreciate that.
Oh, thank you, Wahoo.
Thanks, Wahoo.
Thank you.
So
That's mind blowing.
Yeah,
no,
really
it
is.
That's
totally blows my mind.
well.
Because we're sitting here making an argument, and while you guys were talking, I'm like, you know what? There's got to be some studies out there on this that'll back up what we're saying.
Yep.
So I look it up, and it totally contradicts what we're saying.
Yeah, you guys are wrong.
But it doesn't make sense though. Like when I think about it, because it's the old argument that Fleischer makes and Judge Stevens, some of these other guys make, that would you do open heart surgery on yourself? I mean, the law is a complex thing.
Yep.
And it's hard for me to believe that the average person, is going to be able to navigate that better than someone that has actually trained on it.
Yep.
Well, here's some more data that might help what you're saying or hurt it, or I don't know. But so this first set of data from Hashimoto is basically talking about like before trial, the ability to
right.
To like get a plea, get out of it, whatever the case may be.
Right.
So there is a different study. This is Goldschmidt in 2015. This one said that pro se cases did have a higher rate of dismissal, 17% versus about 6%. So a higher rate of dismissal if you're representing yourself. And, you could argue maybe it's just because the judge doesn't want to deal with it. I don't know. But the study also said if you get to trial, so if you didn't manage to defer it some other way by representing yourself, then the script flips. According to this study anyways, you have a 95% likelihood of conviction as opposed to an 82% if you retained counsel or an 86% if you had counsel appointed to you.
It's not.
So you've got a better shot of getting it like pled down or thrown out or something like that if you're doing it yourself. But if it actually goes to trial, you want to be represented. But even then, it's not like a huge difference. Even with retained counsel, there's still an 82% chance that you're going to get found guilty.
Yep.
Yeah, that makes better sense than the first one you said, Dan. I think that if I was taking a plea anyway, why would I have an attorney kind of represent me? Is kind of what they're saying. They're probably like, if I'm just going to take the plea, why would I have to pay?
Right.
Or why would I need a public defender to do this for me? Because the prosecutor will handle all the paperwork themselves, that type of thing. There's nothing that I really need to do. But if I'm going to trial, you would have to submit evidence, or the prosecutor submits evidence, but you still have to file some paperwork. You have to make sure you have legitimate motions, all that kind of stuff. So I would think that makes better sense to me than going to trial without an attorney, for sure.
I'm still a little bit blown away by the 95 versus 82.
Yeah, the 95 versus 82
that's not exactly great. Yeah, sure. It says you should, if you're going to trial, you absolutely should have an attorney. But if more than 4 out of 5, basically almost 5 out of 6 cases are still going to end up in you being found guilty.
Yep.
Yikes.
Yeah.
Yikes. I don't know. That doesn't exactly bode well for you either way. Sure, it's better than 19 out of 20 where you're boned, but I don't know, man. Having heard those statistics, and again, these are just a couple of studies, and that doesn't mean it's concrete that it's that way, but that's certainly an interesting insight into the legal system, isn't it?
Yes,
it is. So wrong way in the chat, which I don't know if you've joined us before. If you haven't, welcome. Isn't it true that the Fed courts, there's a 97% conviction rate? That is pretty much true. Yeah. And they love to plea out there as well, which counts as a conviction. But the big thing in the federal courts is they'll throw in a mail fraud charge, which has real teeth, and then they'll drop everything else and just get you to plead to the mail fraud charge.
We saw a mail fraud case today.
Yeah.
Yep.
But the Hashimoto study actually also took a look at the number of people in the federal system who go pro se, and at that point, the statistic that was returned was about 0.3% of defendants will actually try to go pro se in the federal system. So they won't even try it there. They're probably heavily discouraged there.
I would expect so.
Well, and again, the feds have a very high conviction rate because generally speaking, the government isn't going after you unless they've got you dead to rights.
Exactly.
Because it's usually those cases are very to even get there in the first place, there usually has to be a voluminous amount of evidence. And you're talking about some serious heavy cases there. So for it to even get there, they usually have you Not to say that it's perfect, but yeah, that's obviously a much different ball game being played.
Yep.
Yeah.
Yeah,
And
Fed court and state court, it's completely different.
And think of the federal statutes, right? And how much larger they are than the state statutes would be. I can't imagine all that information and going through all the federal statutes trying to find what you need to fight whatever you're being convicted of. That would be insane to me.
Yep.
Well, and most people, even with an attorney, aren't even going to try when it comes to the feds. So
Right.
Yep.
Yeah.
you know, that's why that's why the Fed always throws in the easily proven charge, like a mail fraud, and they'll just say, "Hey, here's a gift for you. Plead to this one. Go do your 7 to 10, and
Yep.
we'll drop the rest. It's a gift."
Yeah.
But
Yeah.
I don't know. I'm still trying to wrap my brain around that study, though.
Yeah,
it's,
that doesn't
again,
make
it's one
sense.
it's one
Both of
study,
them.
it's one snapshot, but man, is it totally contradictory to everything we always believed.
Yep.
I mean, I guess I still have to think though that some of those cases are just in the early stages where someone hasn't even been able to find an attorney yet, and they go and they talk to the prosecutor, and they're able to hammer out their own deal, and so that kind of counts as, well, they didn't actually have counsel yet, and so I guess some of that I just attribute to that.
Mhm.
I could see that. now
But
that you say it.
I'm still definitely I'm on that second one that Dan brought up about the
attorney one.
the attorney, the Goldschmidt study there with 95 versus 82.
Yeah.
And I just, now it makes me think, well, if I ever was on trial for something, I mean, at that point, again, it's a better probability, but maybe I just save my money. And
It's not much better.
it's
The
not
82
much. Yeah.
should be a lot lower than what it is, I would think, for what you're trying to get out of an attorney. for
Now,
sure.
Yeah.
Now, on the other hand, if we were to look at this in more of the, I guess what I will call the glass half full perspective, is if the idea is to have people that are guilty go to court. Like, if we look at this as this is absolute, and not saying that everybody that's found guilty is guilty, and everybody that's found not guilty is not guilty, but let's just pretend that that's the way it is, right? Well, that study almost says, hey, the courts are they're batting a pretty high average if the people that are in the system are found guilty, regardless of whether they have representation or not, they're still found guilty. That would suggest that, if we're bringing charges against people, we're bringing charges against the right people, and the system is actually more likely than not to be doing the job correctly and finding the guilty to be actually guilty. Now, that would be the glass half full perspective, and I don't think that's completely accurate, but I was trying to play a little devil's advocate here. The theory behind this is, hey, if you're in court, it's likely that you're in front of a judge in a trial, and we're talking about trials now. If it's gotten a trial, you're there because, you're probably guilty.
Yep.
And another thing, like Michael was saying, if they have the amount of evidence, it doesn't matter what attorney you have. If they have if the evidence is against you, it doesn't really matter what the attorney says, how they vouch for you. You're still going to be considered guilty.
And I want to make sure that I clear this up so that people understand. I'm not saying that if you're on trial, you're guilty, and I'm not necessarily saying that. I'm just playing devil's advocate on the best way to possibly look at that study and what it could be saying about our justice system. Not saying I agree with that. Just saying that that's a way to look at those statistics. It's a how should we say, a positive spin on those statistics? I don't know.
Right.
Obviously we have talked about here and over on the live show, and probably I know we've had just a number of conversations off air about it. All the flaws to the legal system, and the fact that some people, specific groups of people, especially lower socioeconomic groups, certain minority groups, are more likely to be found guilty, are more likely to be given longer terms of probation, are more likely to, and the list goes on. So we know that the system, as much as we like to think it's completely balanced and completely even-handed, we know that it's not. And so the studies within this are not, there's a lot more behind the numbers.
Yep.
I agree.
So, Wahoo asked, side topic, do attorneys that cost more do better? But again, I think that question, Wahoo, kind of goes back to what I was talking about earlier, where it was either Middleton or Fleischer, I forget which one, who swore that if they had to go to trial, they'd want a public defender because of their experience level.
Yep.
Mhm.
And I think
So-
that's Middleton, by the way, that said that.
I think
Pretty
it
sure.
was Middleton.
I think it was. Yeah.
But if that's true, then yeah, the high cost attorney doesn't necessarily do better for you, unless you're at that like concierge elite tier. Think O.J. Simpson trial,
Yeah.
Right.
where he's throwing out millions of dollars
Yep.
to hire an entire team.
Right.
Yep.
Including a Harvard law professor, people who were experts in DNA at a time when DNA was just coming out, so they knew how to shoot it all down. And
Yep.
One guy who's great with the jury, another guy who's great with the media. I mean, he had it all.
Yep.
So if you're at that level, then maybe it's a difference. But if you're average Joe going to trial on some kind of little felony, little in the grand scheme of things, call it like an embezzlement or something.
Yeah.
Right.
Are you better off to get that mid-level $300-400 an hour attorney as opposed to the public defender? Maybe not.
Yeah.
Because I don't know if the data proves it out.
Right.
Right. That makes
Now,
sense.
if you're not hiring your own attorney and using a public defender, though, sometimes they have a big amount of cases that they are siphoning through. Your case will probably be slower to be completed due to the caseload they have. So there is a disadvantage there to a public defender. But we see attorneys that are not public defenders that are heavily loaded too. So I can't really make that argument as well.
Well,
Yeah.
certainly in Jefferson County, we've seen a couple of very interesting public defenders that have been called out for some, and that's and that's the other thing, because we watch enough court from enough locations across the country. It does seem like there's, and again, this is just anecdotal, but it sure seems like the quality of public defender you get in some areas of the country is substantially worse
Yep.
than other areas.
Yes, that's
You know,
Well, it's
yeah.
been
Right.
over a year ago now, but I did a video on this channel about the public defender system,
Yeah.
and it varies drastically depending on where you are.
Correct.
There are some places that have, dedicated offices where that's all they do. They're public defenders. There's other places where they more directly report with the DA's office, and it's like an arm of that, which is really weird. There's
Yes.
other places where there is no public defender, but every attorney in that local system is expected to take a certain number of cases as if they were a public defender. So you're getting like a private attorney, but you're getting them pro bono. So it varies drastically. So yeah, it probably does, Michael, kind of depend on where you're at as to the quality you're going to get, because there's not even a set system across the United States as to how it happens.
No.
Right.
Like in Texas, for instance, how many times have we seen Judge West when she's like, try to get your own attorney, try to get them hired. If you can't find one, come back and we'll get you a public defender. That's kind of unique to Texas. I haven't seen any other state do that. So yeah, I do agree that each one has their own way of going about it. Some of you have to fill out paperwork and make sure you're qualified to get a public attorney. If you have too many assets and stuff, you can't get one anyway. So
Yeah, there's one that appears in Stevens Court, and every time I see him, I go, I would not want, because Stevens is always busting that guy's chops because the guy is always doing something wrong. He's either late or he's this guy. He always has like the details wrong. And he's like, and I don't think the guy, I mean, in fairness to him, I don't think the guy is a day over 185 years old. He's just, I mean, this guy was there. I mean, he's very, very well acquainted with. Yeah, he was right there for the inauguration of John Quincy Adams. And I think, man, when I see my attorney, my public defender, getting yelled at by the judge for something, I'm like, I might want to just go quietly meet with the prosecutor about a plea deal, because I don't know, this ain't going so good here. Yeah.
Yep.
It's just like,
that would definitely be my thought.
Judge Methuselah here ain't cutting it.
The bad thing about it, though, is if you're represented by counsel, the two counsel.
That's a good point. And that could be
one to
another
talk.
rabbit hole to go down, too, is since, like Michigan, they phase out judges when they hit a certain age. Should they phase out public defenders? That's another, yeah.
Yep.
You can argue that point, I guess.
Actually, that's an interesting point. They phase out judges, but I don't think attorneys, even in Michigan, I don't think there's a sunset on when you can practice.
Right.
I mean, I think I think Middleton could get off the bench and he could turn around and still practice law. There's nothing that says he can't, as far as I know, in Michigan. Which is weird that, you can't be a judge, but you can still be an attorney.
Yeah, exactly. So
I'm looking that up right now.
Technically, Judge Middleton can step down as judge, but he's like, I'm gonna be back and be a defense attorney and do that. That's funny. That'll be awesome.
I know pretty damn well that he would never do that, but
so I've got info for Wisconsin on that point.
Go ahead, Austin. Let's hear that.
There is no maximum age limit for a licensed attorney to practice in Wisconsin. However, at age 80, they can switch to emeritus status if they're no longer practicing but want to keep their license. And then at 75, active lawyers are automatically placed into senior active status, which allows them to keep practicing, but it reduces their CLE, continuing legal education credits, and the state bar dues in half. So it cuts what their state bars are, and it cuts how much training they have to take every couple of years.
Oh.
Yeah. Thanks, Austin. Well, you were reading that. I'm looking at a national level, and there's a lot of the same to what you just said, but there is no state in the U.S. that has a retirement or sunset age for their attorneys. But like you
Interesting.
said, there's some areas where they'll back off on their education, the emeritus standing, stuff like that. But interestingly, a lot of larger firms will have a policy of age out. So the firms themselves, usually around 65 or 70, will age out their attorneys themselves.
I could see that.
But not like public defenders or anything like that.
Nope.
Interesting.
That's fascinating.
Yeah, that really is.
Yeah, so that is weird that there's no restriction on an attorney, but restriction on judges.
I don't think that point has ever been made before, but I just thought of it and it's like, that's kind of strange. You would think if it goes for one, it goes for another because judges are technically attorneys.
I'm looking up right now to see who else besides Michigan ages out their judges.
Yep.
I think a lot of
I'm
states
curious on
do, although I don't know if all of them do. I mean, in Florida, we've certainly seen some that are, well up into their 300s and, they're still going strong.
Yep.
32 states have mandatory retirement ages.
Okay.
Age 70, Alabama, Alaska, Arizona. Proposed increase to 75 is on our next ballot, Michael.
Oh, okay.
Connecticut, Hawaii, Louisiana, Maryland, Massachusetts, Michigan, Minnesota, New Hampshire, New Jersey, New York, Ohio, South Dakota, and Wyoming. Why are you licking my ear? That's a little fresh for a live stream, sweetheart. You're going to get YouTube to kick us off. Age 72, Colorado, Iowa, North Carolina, South Carolina. 73 Virginia, 74 District of Columbia, 75 Florida, Indiana, Kansas, Missouri, Oregon, Pennsylvania, Texas, Utah, Washington. The highest is Vermont, age 90.
Wow.
Wow.
I find it fascinating the 71, 72, 73-year-old part and not 70 and 75.
Yeah. Yeah, some of it is very specific.
It's interesting.
Vermont, though, how about that? Yeah.
So if you want to be a judge in Vermont, there's other things you have to
Austin,
do.
you're charged with being a young whippersnapper, I tell you.
Usually you have to live there for a certain amount of time and things, but you could move to Vermont, and if you qualify, you can become a judge there. If you're an attorney.
Yeah.
Interesting.
Yeah.
I guess you're never too old. And I mean, Middleton could just go to Vermont and just pass the bar there and just keep right on going. So that's always an option.
Yeah.
Vermont and the Vatican. You can be ancient and still be in a position of power.
And
Yes.
then Judge Milton will be in the library for the first 15 years trying to learn all the area's lore and everything. So he can do the same thing.
I think he'll become very familiar with everything, all the local businesses, the history of every single block in that town. Gonna miss the guy. I really, really am. Judge Middleton. We're gonna miss him. I mean,
Yes.
That's another reason why. I mean, look, I get it. As you get older, the faculties, they do start fading out. But that being said, if somebody is still capable, I don't see why just because they're 70, you have to automatically, take them off the bench.
Correct. They can still do the job right. Why take them off?
Right. And maybe the theory is that, look, as Alzheimer's sets in or senility or whatever, people can decline very quickly, even within a 2 or 4 year term of service.
Or Parkinson's.
If you elect someone at the beginning of that 4 years, by year 3, they may not know the difference between between a person and a sandwich. I mean, they're just, their brain might just be mush by that point. So I guess the theory is if we just have a hard and fast date where, before things are likely to go downhill too far, that can leave us out of the potential of any sort of jackpot where we're, stuck with a judge that we're going to have a hard time removing from the bench. And, the guy is clearly just asleep on the bench, basically.
Yeah.
Yeah.
I'll
Kinda
miss
like
it.
our last couple of leaders.
Yep. Definitely current and former administrations. I wish we had a provision for that. I mean, we have that for judges. Why not for the top spot in the country? Why not?
That's a good point.
Stop at 70.
That's a good
Michael,
point.
so many things that don't make sense and never
There's,
will.
I mean, we could have just a show about that. Just the stuff that doesn't make sense.
Yeah.
Maybe I'll do that for pre-show tomorrow. I'll make a list of things that don't make sense.
Oh, so we're starting the pre-show at 1 a.m.
That's going to start right after this show.
Yes. Tune in.
Oh, heavens.
An all-night
Well-
pre-show.
Let's finish with this, if we could, just to get it back to the whole pro se argument.
Yeah.
So everybody has a right to represent themselves.
Yeah.
This was a question I had in the back of my head throughout this show. They have a right, but should that be a right? Is that maybe a mistake in the system? Should it be required that you're legally represented?
I mean, the Constitution says you have the right to representation, but it doesn't require that you have it.
Mm-hmm.
So, I mean, and there's definitely a difference between that. So I would say that you should have.
I guess I'm asking, is the Constitution written wrong there?
Yeah, I mean, that's a good question. That's a great question, Dan. I mean, really, of course, your immediate reaction is, well, yeah, I mean, you should, but should you? I mean, is it something that, based on the statistics we heard, based on the studies that you said, now again, they're just a couple of studies. It's not this isn't a set in stone gospel sort of thing. This is just, some numbers, but I don't know. That's a great question.
I think of it the other way. Since the Constitution was first, are the states wrong?
What do you mean?
For instance, if everyone is, according to the Constitution, they are, what's the word? They are
Entitled to representation.
Yeah, entitled to representation. And states put kind of a barrier on that. Shouldn't all the states kind of do it the same way? Because if they're following the Constitution, they wouldn't have that barrier on if who is entitled to a public defender or not type thing.
Yeah, I guess I'm just asking is, should it be a requirement that you're represented? rather than like a right to representation, should representation be a requirement?
I think as long as the defendant, I don't want to say like a mini bar exam, but like as long as they know what's going on and can effectively and efficiently get through a trial, then you should be allowed to do it yourself. But if you're struggling for the most basic things that are holding up the court, then at that point, yeah, you need representation, in my book.
Yeah, and look, I don't like the idea because I'm the
No.
we've got too many laws guy.
Yeah.
So I'd like everything to be simpler,
Yeah.
but you
Yes.
know that's never going to happen.
Exactly.
So because that's never going to happen, it makes me wonder if the Constitution isn't written wrong, and if we need an amendment that says if you say
don't think so.
say felony level or higher, that
Mhm.
you're not only you have a right to representation, it's a requirement that you have it, and if you can't afford it, we'll pay it for you, but you're required to. It's not an option for you to go pro se.
Yeah.
I don't know.
I don't.
Because it's such a minefield for everybody, and it's not
Right.
going to.
And
It's just not.
I don't think
Right.
so, because just like Wrong Way is saying, you can represent yourself and be stupid. And I feel like people are entitled to be stupid or not stupid in a way.
Yeah, yes and no, because the problem with that is you're wasting everybody's time
Yep.
and their money. That's part of the thing here too.
Yeah.
Is we can say, people they can be stupid if they want, and they're only hurting themselves and all this, and these arguments that we say, and I wonder if we make these arguments to make ourselves feel better about the stupid things that we've done and the choices we've made.
Right.
But quite honestly, if anything elevates past yourself, your stupidity is affecting others. Never in a good way. And it's taking other people's time and money.
True.
True.
So I don't know.
Yep.
Very interesting. It's this is one of these. That's Dan. That's I'm left with a lot to think about on this one. This is
yes.
This is a sidebar where not only did we not necessarily find answers, but I think we are left with a very fascinating set of questions.
Well, Wahoo would like us to continue the discussion, so perhaps sometime we circle back, if not next Tuesday, at some point in the future.
I think this is one that
back up.
It will come back up. And, at the end of the month when we do our chat controls the topic section, I'm sure this is going to come up again. And I think it's a fascinating topic because not only is self-representation such a big deal in the court system, but, the effectiveness of counsel, the fact that it's so expensive to get your own counsel, all the different aspects of all of it. I mean, there's so many nuances to the legal system, and obviously it's set up by legislatures, which are lawyers. It's set up to be this way on purpose. I mean, people don't spend all that money to go to law school just so they don't make money,
Yep.
We'll end with this. Wrong Way says the Constitution is about individual rights, not feelings. I totally agree with you. I am, since you're new here, I'm very conservative in most of my views, although not necessarily in punishment. I'm a big believer in the Constitution, but I don't think, like any document in the world, that it's 100% right. I think there are areas where it could be improved. But the one thing we do here is we explore. So that's why I brought up the question. Not that I had an answer to it. I don't know. I'm just
right.
Question.
Yeah, this is one of those.
Does it make any sense whatsoever to require that somebody has counsel? And maybe it does. Because
especially for higher level. Yeah,
especially not for misdemeanors, but I could probably agree to a higher level amount.
Yep.
No. All right, we're out of time. Final thoughts, Austin? Anything?
It's having a lawyer can help you, and it can unfortunately affect your case negatively if the person doesn't know what they're doing, or if they're so overloaded that they miss something crucial. So that's a darned if you do, darned if you don't, in my opinion, with certain things.
Such harsh language.
I know.
Like Austin says, you have the right to represent yourself, But as this case showed, sometimes that right becomes his own punishment. And Judge Oakley tried to steer him right. He tried to warn him, but the defendant had to learn for himself. And that is just the game you play. The judges are there for a reason. They don't want to see the downfall of individuals. They want to assist however they can as well. So maybe I kind of think of it that way. Those are kind of my final thoughts. He should have taken the judge's advice. He tried to get him out of that situation, but he just wasn't budging.
Yeah. Michael?
Well, from a content standpoint, I definitely want to see more pro se. And, I guess based upon statistics, maybe more pro se is the way to go. We learned something here today. How about that?
Well, sometimes we do that. So I guess I'd like to end with the concept that I've brought up many times before, and that's that I love the discussions that we have here, because this is how it should work.
Correct.
People coming together and talking things out and exploring different ideas and all of that, and it's just not that hard to do, is it? But the world makes it seem like it is.
Yep.
But here we are having a good convo, and I think that's what really matters.
Very
So
much.
thank you guys for having a good conversation with me tonight.
Yeah, thank you.
I enjoy it.
So let's come back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. So wrong way, 9 a.m. Eastern, 6 a.m. Pacific.
Yes.
Come back where we do the Courtroom Files live, TCF live, where we bounce from court to court to court and have a lot of fun. And tomorrow is Super Friday. Why do we call it Super Friday? Because we're better than most people, so we don't have regular Fridays. All right, friends, this was fun. I'll see everybody in the morning. Take care.
Have a good night,
Bye-bye.
y'all.
Good night.